the Good and the Bad with Alysha. I hope everyone is enjoying their winter break. I am going to go ahead and try to knock out the rest of the segment before the end of the month and then switch over to a new topic. So if there's a particular class or textbook you'd like to hear me go over next, please feel free to make a suggestion in the comments below. In today's video, I'll be discussing Chapter 9, the Judiciary, from the textbook Governing Texas. In this chapter, we will learn how the Texas court system is organized, the legal process and the differences between criminal and civil law, the process for selecting judges in Texas, and the impact of recent changes related to tort reform, regulation of lawyers, and disciplining judges. Some critique the Texas criminal justice system, saying that it has deep flaws. These flaws include partisan elections where judges make political calculations in order to gain office, followed by intensely political judgeships. In many instances, judges are appointed by the governor, which we learned more about in Chapter 8, the executive branch. The story of Justice David Lewis and his declining health and eventual death was tragic, but also raised questions about the judicial system and judicial discipline. Could a different system have removed Justice Lewis sooner? Did our current system fail him and the people of Texas by not moving quicker? Texas has a large, complex court structure made up of multiple courts with overlapping jurisdiction, with one key responsibility: to secure liberty and equality under the law. The highest level of civil court in Texas is the Texas Supreme Court, consisting of 9 elected justices and has final state appellate authority over civil cases. The Texas Supreme Court also handles juvenile cases. The Texas Court of Criminal Appeals is the highest level of criminal court in Texas, consisting of 9 elected justices and has final state appellate authority over criminal cases. One of the most important roles of the Court of Criminal Appeals is the jurisdiction over automatic appeals in the death penalty cases. Requirements for becoming a Texas Supreme Court Justice or Texas Court of Appeals Justice include being at least 35 years old but under the age of 74, and to have been practicing law or been a judge for a minimum of 10 years. Both courts serve 6-year terms and make $168,000 a year, and the Chief Justice gets an additional $2,500 a year. Appellate authority is the authority these courts have to review decisions of the lower courts to determine if legal principles and court procedures were followed correctly or not. If mistakes were made, the court can order a retrial. Texas has 14 other appellate courts or courts of appeal that hear appeals from the trial courts. Usually a case will come here before it gets to the Supreme Court or the Court of Criminal Appeals. Currently, 80 judges serve on the 14 courts of appeal, which range in size from 3 to 13 judges. The requirements for a Court of Appeals justice are the same as those for justices of a higher court, but they're paid a little less at $154,000 a year, but this can be supplemented with additional funds and longevity pay. The Chief Justice of each Court of Appeal receives an additional $2,500. District courts are the major trial courts in Texas. Every district is served by at least one district court. These courts usually have general jurisdiction over a broad range of civil and criminal cases, things ranging from divorces and felonies to election contests and civil lawsuits. In some more urban districts, courts may be specialized to hear only one type of issue. There are currently 465 district courts, each with one presiding judge. The court judges make $140,000 a year and can receive up to $18,000 from the county supplement payments to the state salary. On top of the salary, they get longevity pay after 16 years of service. They receive 3.1% of their monthly salary each year. Specialty courts are created to address particular crimes or serve particular populations. These courts are part of the district courts and focus on trying to rehabilitate those with underlying problems that can lead to reoccurring criminal behavior, like those with mental health issues, alcohol and drug abuse issues, and those arrested for prostitution. There are currently 191 specialty courts with one presiding judge. 43% of these courts were drug courts in 2016, making drug courts the most common specialty court by far. It was found that offenders who complete a drug court program are less likely to reoffend than offenders who do not complete or who do not participate in the program. Upon successful completion of a specialty court program, charges are dismissed. Veteran courts are another one of the most common specialty courts in Texas, in which cases are heard for veterans who have suffered from brain injury or mental issues from military service in a combat zone and have been charged in a criminal case. Each one of the 254 counties in Texas has its own county judge that presides over the county commissioner's court and has responsibilities for administration of county government. A county judge can also sometimes preside over a county court where they have jurisdiction over probate cases, minor civil cases, and serious criminal misdemeanors. The county court can also hear appeals from municipal courts or justice of the peace courts. Many county judges combine their political administrative functions with some judicial functions. Some more populated counties have eliminated most, if not all, of their county judges' judicial duties. County court judges can receive an additional $25,000 in compensation if they sign a single-page declaration at the start of the year promising that 40% of their work will involve court cases. An investigation concluded that many judges that receive this extra compensation haven't actually spent 40% of their time on court cases. Despite the investigation, nothing has been done to audit judges signing this declaration. Statutory county courts at law are created by a statute. The jurisdiction of these courts can vary greatly. These courts typically hear appeals from justice of the peace and municipal courts. Sometimes these courts hear less serious criminal cases, and sometimes they hear civil cases involving less than $200,000. Statutory probate courts are highly specialized courts dealing with matters relating to the disposition of property of deceased persons, guardianship of people unable to handle their own affairs, and commitments of people to mental health institutions. Statutory probate courts are more popular in urban areas, and in other parts of the state, depending on the statute, probate matters may be heard by the county court at law, or the district court. Each county has between 1 and 8 justice of the peace precincts, for a total of 802 courts and judges. These courts are local trial courts with limited jurisdiction over small claims and very minor criminal misdemeanors and civil matters. Justices of the peace may issue search warrants and arrest warrants. Justices of the peace mostly handle traffic misdemeanors. Between September 2016 and August 2017, 71% of the cases were traffic related. Only about 10% of the justices of the peace in Texas are lawyers, and the justices' lack of legal credentials has led to considerable debate in the state. Municipal courts are local trial courts with limited jurisdiction over violations of city ordinances and very minor criminal misdemeanors. There are currently 1,326 municipal courts and judges in Texas. Municipal judges may issue search and arrest warrants, but they have only limited civil jurisdiction. Municipal courts also function mostly as traffic courts. The law is divided into criminal and civil law, each with jurisdiction over particular types of cases and with specific procedures. Civil law deals with disputes, typically between private individuals over relationships, obligations, and responsibility. In civil law, the plaintiff files a complaint presenting their grievance to the court. A lot of the time, the plaintiff hires a lawyer on a contingent fee basis that allows the lawyer to collect a percentage of the damages if the case is won. Lawyers who handle cases on a contingent fee agreement often handle personal injury cases and are known as trial lawyers. Traditionally, these lawyers will contribute money to judicial candidates who are sympathetic to plaintiffs. The defendant files an answer, the defense against an allegation. The defendant will usually hire an attorney working for an hourly fee that is paid whether the case is won or lost. If they are an insured person, then the insurance company will pay for the attorney. Defense lawyers contribute large sums to judicial campaigns to elect judges who support their views on tort law. Civil cases are usually settled out of court and can happen before, during, or after trial. A civil trial may be heard by a judge or jury consisting of 6 or 12 jurors, depending on the level of court. A verdict is rendered by at least 5/6 of the jury using the standard of preponderance of evidence, the standard of proof by which the plaintiff must show that the defendant is more likely than not to have caused harm suffered by the plaintiff. The verdict may be appealed, usually from the trial court to the Intermediate Court of Appeal and on to the state Supreme Court if necessary. Litigation is time-consuming and expensive. As a result, in Texas and in other states, it's increasingly common to try to negotiate a settlement through mediation or arbitration. With arbitration, the parties to the dispute agree to present their case to a decision maker and to be bound by that decision. With mediation, the parties to the dispute try to reach a compromise without going to trial and are not bound by any decision. Criminal law is the branch of law that regulates the conduct of individuals, defines crimes, and specifies punishments for criminal acts. The state acting as the plaintiff alleges a violation of criminal law and is then represented by a prosecutor. Career prosecutors with lots of trial experience typically handle capital cases. On the other hand, working for the state pays a lot less than working for a private firm, so many prosecutors are young and inexperienced and usually leave for a private firm after gaining experience. The defendant is represented either by a hired attorney or a public defender appointed counsel. Most court-appointed lawyers don't make nearly as much as other lawyers, leading to issues with the quality time spent on the case. This may be one of the reasons that most defendants are found guilty. Felonies are serious criminal offenses punishable by a prison sentence or a fine. A capital felony is possibly punishable by death. Misdemeanors are minor criminal offenses, usually punishable by a fine or a jail sentence. Before a trial occurs, there's an indictment by a grand jury to determine whether sufficient evidence is available to justify a trial. An indictment can also be referred to as a true bill, while no indictment is referred to as a no-bill decision. The grand jury is made up of 12 people and 2 alternates who sit for 2 to 6 months. Depending on the county, a grand jury may meet only once or twice a year, or it may meet several times a week. New legislation now requires that grand juries be selected randomly from a pool of qualified citizens instead of being selected by several grand jury commissioners. Grand juries work in secret, usually relying heavily on the information provided by the prosecutor. If indicted, the defendant has a right to a trial by jury, 12 jurors for felonies, 6 jurors for misdemeanors, where the verdict has to be unanimous, proven beyond a reasonable doubt. Sentencing occurs upon declaration of a guilty verdict. A defendant may choose to waive the right to a jury to request a bench trial, which is held before a judge only, or take a plea bargain, in which a defendant agrees to plead guilty in return for a negotiated agreement that can reduce the severity of the criminal charge or prison sentence the defendant is facing. If a guilty verdict is returned, there will be a separate hearing on the sentence, which in Texas is sometimes also determined by the jury. The defendant may then appeal the guilty verdict, usually alleging a trial error may have affected the outcome. Criminal defendants appeal their convictions to an intermediate appeals court and then maybe to the Texas Court of Criminal Appeals. In capital cases, the appeal is made directly to the Texas Court of Criminal Appeals. Texas elects its judges, unlike the federal government's lifetime appointment system. The election system is very controversial in terms of the partisan nature of the judicial selection. Federal judges don't have to be concerned with how their decisions will be received like Texas judges do. Even though many judges are appointed in Texas like federal judges, eventually everyone has to run for election and are subject to politics. These politics typically include special interest groups who use their money to influence judicial campaigns, raising questions about the relationship between the rule of law and the nature of democratic politics. The governor appoints judges to district and appellate court vacancies and to fill judgeships in new courts, leading to a large percentage of judges initially becoming judges through appointment. This gives the governor a lot of power over the judicial system. Because Texas was historically a one-party Democratic state, the selection of judges in partisan elections wasn't as controversial in the past. That is up until 1978 when Clements, the first Republican governor since Reconstruction, was elected and appointed Republican judges. These Republican appointments resulted in re-elections, causing the fight for judicial seats to become more competitive and costly. Lawyers and interest groups tend to be the biggest donors to judicial campaigns. Often trial lawyers back Democratic judges who are more likely to lean liberal or pro-plaintiff. Civil defense lawyers may back Republican judges who are more likely to be conservative or pro-defendant. One difference between the campaigns of civil court judges and the campaigns of criminal court judges is the amount of money involved. A candidate for the Texas Supreme Court may raise around $1 million for a campaign, whereas a candidate for the Texas Court of Criminal Appeals may raise only around $100,000. Contributions and contributors for judicial races raise concerns about how neutral Texas judges are. A poll of judges showed that 86% believe that the campaign contributions had some influence on judicial decisions. There are three main concerns for judicial reformers: changing the system for selecting judges, increasing minority representation on the bench, and restructuring the judiciary to make it more rational and efficient. There are concerns over the low visibility of judicial elections. Texans typically have limited knowledge on the qualifications and abilities of judicial candidates, simply relying on party labels during elections. There are also concerns that voters may just be picking the most attractive name on the ballot. A 2008 election showed that those with more eccentric names were more likely to lose. Similarly, names were proven to be an issue in the 2016 election when Rick Green and Paul Green nearly tied, and again when Richard Walker won the election after using his middle name Scott on the ballot and potentially being confused for a well-known Republican governor of Wisconsin, Scott Walker. Another issue typically plaguing urban areas is the sheer number of names on the ballot, making it nearly impossible to make an informed decision. One of the proposed ways to solve these issues has been to switch to a merit selection process. Judges would be nominated by a blue ribbon committee, then appointed by the governor and approved by the Senate. After a year in office, they'll run in a retention election where voters would determine whether to keep the incumbent in office. To promote the selection of an individual candidate, the legislature banned straight-ticket voting, where voters check a box by one of the political parties on the ballot, which casts votes for every candidate on the ballot with that political party affiliation. Most winning Texas Supreme Court candidates get their campaign contributions from the oil and gas industry, lawyers and lobbyists, and the financial sector. This raises questions about the contribution limitations. This concern led to the only successful reform, the Judicial Campaign Fairness Act, which places limits on judicial campaign contributions. Most notably, the act limited individual contributions in judicial campaigns to $5,000 and $30,000 for law firms for statewide candidates. Texas is the only state with campaign finance regulations of this type. While there are many different ways to select judges, like the merit selection process, partisan elections, nonpartisan elections, appointment by the governor, and selection by the legislature, it doesn't seem likely that change will happen anytime soon as far as the judge selection process in Texas goes, because a major change would likely upset voters, lawyers, judges, and political parties. A majority of judges in Texas are white, well-educated, upper-class men. This nowhere near reflects the current population of Texas, where women make up roughly 50% of the population by gender, and Hispanics and African Americans together also make up roughly 50% of the Texas population by race or ethnicity. Some reformers want to see the judicial system reflect the people of Texas. Professor Sherry Lynn Eiffel has argued that diversity among judges is necessary for impartiality in judicial decision-making, public confidence in the court system, and the perception that society as a whole is represented on the bench. Civil rights groups have argued for the redrawing of smaller judicial districts to give minorities a voice that they don't have in larger white-dominated districts, but Latino and African American groups have been unable to agree on new district lines. The business groups are also concerned that smaller districts will lead to elections of judges whose larger minority constituents might be hostile and favor individual plaintiffs in lawsuits against businesses. Another roadblock minorities may be facing in not winning elections is that there just simply aren't enough of them running, and the ones that do are running as Democratic when Texans are voting Republican. Being a lawyer is a requirement for becoming a judge, except for a county judge or a justice of the peace. But with only 5% of lawyers in Texas being African American and only 9% being Latino, it's no wonder that there aren't more minority judges. Judicial districts in Texas are not subject to one person, like the county commissioner, and thus not subject to redistricting according to the one person, one vote standards used to redistrict legislative bodies. This results in jurisdictions overlapping for many courts. Cases can be randomly assigned to overlapping courts, resulting in opposing decisions and a lack of certainty or predictability. With the passage of time, the Texas judiciary system has become less effective. This can be seen at all court levels, like the appellate court in the Houston area to the district courts in Anderson County. The idea of having multiple courts was that each level was supposed to have its own jurisdiction that was consistent at each level. This has not been the case. The judicial system can be described as a hodgepodge of jurisdictions and a patchwork array. One of the most important issues in Texas has been tort reform, which is the effort to change the system for awarding damages in lawsuits where harm is claimed. The Texas Supreme Court sets the tone for civil cases throughout the state. Tort law cases in which one person has been harmed by the actions of another, are the most important type of civil cases because of the large amount of money involved. The partisan nature of the courts in Texas allows interest groups to influence judicial elections in favor of either the plaintiff or the defendants in civil suits. Today, the Texas Supreme Court is quite favorable to defendants in civil cases, in part because it's now an all-Republican and conservative court, especially in the case of malpractice lawsuits. To practice law in Texas, one must be a licensed lawyer who has completed a Juris Doctor and an accredited program and passed the Texas State Bar exam. The State Bar of Texas is both a professional organization and an agency of government which enforces ethical standards for the profession and disciplines lawyers for infractions. All licensed lawyers in the state must join and pay dues to the State Bar. Illegal generation of litigation is commonly known as barratry, and the state legislature has become so concerned about lawyers inappropriately generating legal business that in 2011 it passed new legislation that allows for a penalty of up to $10,000 and the recovery of attorney's fees. The goal of this legislation was to prevent what's commonly known as ambulance chasing, which appears to remain a problem in spite of long-standing state bar rules against it. Some of the horror stories of barratry include people being solicited to sign contracts with lawyers for lawsuits at home, in hospitals, and even during funerals. At times, the relatives of accident victims have been offered large payments to sign a contract with a particular lawyer to file a lawsuit. In order for the state bar to discipline a lawyer, of course, a finding of wrongdoing is required. When a lawyer is charged with a criminal offense, they can practice until the court finds that they're guilty of a crime. This can lead to bizarre situations. There has been question about if there are too many lawyers in Texas, creating too much competition considering all the law schools and the ability of out-of-state lawyers to take the Texas bar exam. The State Commission on Judicial Conduct was created by a constitutional amendment in 1965 and was charged with investigating allegations of judicial misconduct and disability, as well as with disciplining judges. This is an alternative to the rare impeachment by legislation or criminal prosecution of judges. There are 13 unpaid members who serve 6-year terms and 14 paid staff members. It is a hybrid agency with 2 attorney members appointed by the state bar, 6 judicial members appointed by the Texas Supreme Court, and 5 citizen members who are appointed by the governor. All of them are confirmed by the state senate. The commission relies on complaints from the public, from attorneys, and from members of the judiciary in order to deal with disciplinary issues involving Texas judges. The Commission's decision-making is done behind closed doors, lacking openness and transparency. The Commission can recommend public censure or removal of a judge or the judge's involuntary retirement to a review tribunal composed of the Chief Justice of Texas and 6 appellate judges. The tribunal's decision can be appealed by the affected judge to the Texas Supreme Court. Many of the disciplinary actions of the Commission involve private sanctions of the judge. Often, with private or public sanctions, judges are required to seek additional legal education. In this chapter, we learned about the judiciary in Texas. Texas elects its judges through partisan elections that for many years were dominated by the Democratic Party and were low-budget affairs. In the late 1990s, the Republican Party grew, and with it, the judicial elections became highly competitive, political, and expensive. The Texas Supreme Court sets the tone for tort law. This causes candidates backed by business interests to be pitted against those backed by plaintiffs' lawyers. As the Democratic Party weakened, judicial races became less competitive across the state. Many voters in judicial elections choose candidates based on party affiliation or name appeal because very little is known about the judicial candidates, leading to many close races and problems. Some have argued for a change to a merit selection process, while others have argued that to reduce the size of judicial districts in order to increase minority representation. No major changes have been successful because coalitions cannot agree on changes, and there is serious opposition coming from political parties and business interest groups. Texans also seem to like the election process and would likely put up a stink if that right was taken away from them. The only changes to the judicial election process to date are the Judicial Campaign Fairness Act and the new law that bans straight-ticket voting starting this year. There is some concern that without straight-ticket voting, there will be even less voter turnout. The method of selecting judges continues to be the most controversial area of the Texas justice system. One may question whether or not a criminal justice system in which the judges and prosecutors are elected creates political pressure to gain convictions at any cost. With no results for decades now, it seems safe to say that change isn't coming anytime soon, especially since minor changes in the judiciary, such as redistricting trial court, seems to be such a low priority in Texas. Texas will continue to have confusing, overlapping judicial jurisdictions for years to come. Now let's review our objectives for this chapter. So our first objective, how is the Texas court system organized? The appellate court system in Texas is divided into civil and criminal tracks, with the Texas Supreme Court being the highest state-level court for civil cases, and the Texas Criminal Court of Appeals being the highest for criminal cases. Texas has an intermediate appellate court system and trial courts that range from district courts for the most important criminal and civil cases to county courts for less important criminal and civil cases, to justices of the peace and municipal courts for settling the lowest level of conflicts. What are the legal processes and the differences between criminal and civil law? Civil law is dramatically different from criminal law, with the burden of proof relying on different standards. Plaintiffs are the initiators of legal actions in civil cases. Defendants in civil cases respond to accusations made against them. Civil cases may lead to trial or dismissal by a judge. They may also be resolved by a settlement between the parties. The state is a prosecutor in the criminal case, and the accused individual is the defendant. Criminal cases can result in a trial, a dismissal, or a plea bargain. What is the process for selecting judges in Texas? Partisan elections make judges accountable to voters, but critics claim that unqualified judges are elected solely because of their party labels. These critics advocate alternatives for choosing judges, such as a merit selection process. Minorities are not proportionally represented, possibly in part because most judges are elected from large districts that are non-minority. What are the impacts of recent changes related to tort reform, regulation of lawyers, and disciplining judges? Texas courts make decisions affecting Texans on a variety of issues, including the ultimate penalty of death and tort cases such as medical malpractice. So that's all for this chapter. Thank you so much for joining me. I hope you learned something new today. And as always, please remember to like and subscribe down below. Thanks. Have a great day.